contest actual fair charge. Now look at the way I put that. I didn't say it's wrong. I didn't say it's a gray area. I just said if some airline says that that's not a good fare, if they contest it and charge you, it says in charge, an agency is debited. Customer shall indemnify agency for any additional monies carrier requires agency to pay. All I'm asking is if your customer wants the fares and there is maybe a question as to the date that you've written the ticket, or maybe a question as to some of the requirements, at least give me something that if we have to try to collect later on when you get all these debit memos, I can show the consumer and say, look, this was you who requested the fare. The agent on a lousy 10% can't afford to pay 60% increase. It's your... So, future-wise, maybe it'll never approach you, but when in doubt, take that ball and shift it to the other court. I don't want you getting these memos the way you have. Sure. This ticket fare structure is requested by customer. Boom. That's the whole theory. It's yours, baby. Take it. If carrier contests actual fare charge and agency is debited, customer shall indemnify agency for any additional monies carrier requires agency to pay. What about the debit memos that you know you're right on, not questionable fares, but that you seem to get on a weekly basis now? When the carrier threatens you of cutting the umbilical cord, shutting off your computer until you pay a debit memo, and you know you're right, that's extortion. It's a felony. And I have no qualms about you going to your district attorneys and filing a criminal complaint for extortion. You would if anybody else tried to blackmail you. I see no difference there, if you're right. At the same time, if you have to pay to protect your screen and to protect your CRS system from not being shut off, you might pay it, quote, under protest, and then bring them into small claims